Legal maxims are concise expressions of fundamental legal principles that have developed over centuries, providing guidance to legal professionals. In this compilation, we explore 10 legal maxims to illustrate their application in the legal context. Ubi jus ibi remedium. Where there is a right, there is a remedy. This maxim underscores the fundamental principle that when a legal right is violated, there must be a corresponding legal remedy available to the aggrieved party. For example, if someone's property is unlawfully taken, the legal system provides remedies such as compensation or restitution to rectify the wrong. Ignorantia juris non excusat. Ignorance of law is no excuse. This maxim implies that individuals cannot avoid legal consequences by claiming they were unaware of the law. Ignorance is not a valid defense in criminal or civil cases. For example, if someone violates traffic laws unknowingly, they can still be penalized. Fiat justitia ruit caelum. Let justice be done though the heavens fall. This maxim emphasizes the importance of upholding justice even if it has far-reaching consequences. It signifies that the legal system must ensure fairness and equity even if it means challenging established norms. For example, a corrupt and influential business tycoon will be prosecuted and sentenced to prison despite the potential economic repercussions. Nemo dat quod non habet. No one can give what they do not have. This maxim applies in property law, emphasizing that a person cannot transfer better title to property than they possess. For example, if someone sells stolen goods, the buyer does not acquire legal ownership. Res ipsa loquitur. The thing speaks for itself. This maxim is used in negligence cases. It means that if an accident or injury occurs under circumstances that would not typically happen without negligence, the burden of proof shifts to the defendant to prove that they were not negligent. For example, if a surgical instrument is left inside a patient's body after surgery, this maxim will be applied requiring the hospital to prove they were not negligent. Volunti non fit injuria. To a willing person, injury is not done. This maxim asserts that if an individual willingly assumes a risk or consents to a potentially harm activity, they cannot later claim that they were wronged. For example, in sports, participants accept certain risks inherent to the activity. Caveat emptor. Let the buyer beware. This maxim places the responsibility on the buyer to exercise due diligence and be cautious when making purchases. It means that buyers should inspect goods, ask questions, and be aware of potential risks before entering into a contract. For example, when buying a used car, the principle of caveat emptor suggests that the buyer should thoroughly inspect the vehicle's condition before purchase. Quod ab initio non valet in tractu temporis non colvasere. What is invalid from the beginning does not become valid with the passage of time. This maxim emphasizes that time cannot cure or legalize an action that was initially void or invalid. For example, a contract that was void from the outset cannot become valid through the passage of time. Doli incapax, incapable of wrongdoing. This maxim is used in criminal law to refer to the legal presumption that children under a certain age are incapable of forming criminal intent. A 7-year-old child cannot be held criminally responsible for theft. In pari delicto, in equal fault. This maxim signifies that when two parties in a dispute are equally at fault, the court may not grant relief to either party. For example, in a case of two business partners involved in an illegal scheme, the court may apply the doctrine, denying legal remedies to both. Hope you found the video helpful. Stay tuned for the next one.